and welcome. This is a Disability Law Show back again. John Scholes, your host. With me, Tamar Agopian, partner, Samfiru, Tumarkin, LLP. Just happen to be the most positively reviewed law firm in the country. Tamar always says reach out to her, talk to one of her team. If you have problems and issues with your insurer, whether you've been cut off, been told to appeal, there's a million different things they can throw at you, so arm yourself with knowledge. The phone number, 1-855-821-5900, help@disabilityrights.ca through email. And there's a few more things you want to be aware of throughout the show. I'll give you those as the show goes on. Tamar, how to transition from short to long-term disability benefits. We're going to get to that a little later on the show, but we always start with a week that was, something you've been working on. You can enlighten us, and we'll drill down on it a little bit. What do you got?
Absolutely.
Yep.
And so today's week that was, I would say, is something that's really a core value at our firm, which is that we really commit to discovering your rights both on the employment side and the disability side, John. And yes, this is a disability law show. Yes, we have a whole dedicated show on employment law. But this feature that I want to talk about is something that I think touches on both elements. Mm-hmm. So this individual came to us about a year and a half ago, and he was speaking to us about how he was having some real difficulties in terms of getting back to the work setting as a result of his health issues. And the challenges he was having really were partly to do with his workload. He described himself as a workaholic, really dedicated to his employment, and then ended up having a burnout type situation, really needed a lot of support, variety of different health issues. And his employer said, look, we think you should be going on disability. So he went down the path with the disability insurer. What the disability insurer tried to do was actually get him more support through their own rehabilitation service providers. And in that was reaching out to the employer to say, hey, will you allow this individual to return back to work in an accommodated setting? Mm-hmm. Let's give it a try and see what would happen. And the employer resisted that return to work. And so he had some challenges with that, some back and forth with the disability insurer. Long story short, of course, the disability insurer got antsy and cut off the claim after they did a variety of other things. And
right.
So when he came to us, he sort of was coming to us with his hands sort of up in the air thinking, I want to give up. I'm exhausted. I've been through so much as it is. Where do I go from here? I've got barriers with my employer and barriers with my disability insurer. And in his situation, John, the key thing was that we really do want to focus on the disability first. If the individual is still having the support from their doctor or doctors, in this case there was multiple specialists who were saying he is not capable of working, regardless of what the disability insurer wanted, then that really is the primary focus. And that's really what we want to do, is support someone through their disability claim, and then afterwards we will revisit whether or not there's a basis for a claim against the employer. And that's exactly what we're in the process of doing now. The disability claim was successfully resolved. Within that year of being retained, by the way. We did it at a mediation. It's all confidential, but it was a successful resolution. And now we're focusing on the employment claim. And we're really well suited in terms of doing that, because we have lawyers, much like myself, who are not only experienced on the disability side of the claim, but also the employment side of the claim. And we will make sure that your rights are protected on either side, so that you're not having to feel that you're compromising one element of your potential legal rights and compensation by virtue of pursuing one claim at the expense of the other. We want to avoid that, John. And I thought it was an important topic to start off the show on, because, you know, sometimes I wonder whether people realize that we actually are experts in both fields. Mm-hmm. And we really do want to focus on disability if we can, but also be mindful of that employment claim.
Well, you did mention this particular client had a cadre of medical people behind them saying, pleading their case. Is that something the insurance company is bound to do on their own? Well, we're going to have our people have a look because we want to get you back to working off claims. So be prepared, right?
Absolutely, and that is one of the tools in their tool chest of things that claims adjusters will want to do, is to push upon you one of their own service providers so that they can then govern what it is that's happening from a health perspective, and because they know that the bills are being paid by them for this treatment provider. So inevitably, it's not an unbiased process, folks. You're going to have the disability insurer paying for this treatment for you. You can bet that the goal of that treatment is to try and get you back to work as soon as humanly possible. And so what you don't want to let go is the opportunity of getting that treatment from one of your own service providers. if your doctor can refer you to someone similar who is as well suited, but it's someone that your doctor referred you to, then it creates what's called arm's length. There is some distance between the disability insurer and the treatment provider. And John, that's critical sometimes, because what may happen is you might have different opinions. The disability insurer's treatment provider's opinion might be that you're ready for work, but your own medical team may be saying, he's not yet ready. And that's really what can assist potentially in challenging the disability insurer and wanting to hastily cut off your claim as soon as they've got you a little bit of treatment, 8 weeks and you're good to go, which is exactly what they tried to do with my client.
It's interesting too, though, because even the insurance company's medical team or their assessors, I mean, we know who's paying them. At the end of the day, we know who's paying them. And there's been cases that you've talked about where sometimes it's not even a physical visit. Sometimes it's a review of a paper file. I don't know how that holds water in any courtroom at all.
It doesn't.
They've never even seen you.
Yeah, it doesn't at all. And so, the paper review is something that's a first step for a lot of claims adjusters, because many of them just simply don't have any medical background, John. They've never worked in any sort of medical setting. This is sort of an entry-level type position that they've got at most insurance companies. And, they may have a little bit of experience in terms of perhaps a rehab background or some other thing, but certainly not specific medical field, and certainly not specific to certain types of disabilities that we see quite often. Not a chronic pain specialist, not a fibromyalgia specialist, not a mental health specialist. So look, in a setting like that, you do want to make sure that if they are doing a paper review, and if the documentation, so to speak, that you've submitted to the insurance company is being sent to one of their hired guns, so to speak, and they haven't met you, they haven't talked to you, they haven't talked to your doctors, and they are giving an opinion to the adjuster that your claim should be closed. This is where you want your medical team to step up, provide their own comments and challenges on the conclusions the insurance company has made about relying on that medical review to close out the claim.
Now, you did mention part of this equation was with the employer. So if you were to put, and you own one, your employment law hat on for a moment, this duty to accommodate and the fact that they wouldn't budge. Are they even in the process at this point? Do they even have a say, the employer, at this point?
Well, look, I think that if you're in the umbrella of the disability insurer, most employers will sort of back off a little bit. They expect the disability insurer to be adjudicating your claim, dealing with you one-on-one, and they will get updates from the disability insurer, your employer that is, about what's happening with your claim. And rightly so to some extent, because your health information is actually private as it relates to your employer. You don't really want all of that to be disclosed to your employer when you've actually got the disability insurer there to deal with your disability claim. Don't forget, the employer is entitled to know, John, your prognosis. They are entitled to know when you might reasonably expect to return back to work.
Right.
But they're not necessarily entitled to know the details as to why you are off. And especially in the situation I described at the top of our show, when the employment situation is what impacts your health, you especially don't want your employer to necessarily know that that is the reason why you are on a leave. Where it becomes more relevant, as you said, is if you are trying to facilitate an accommodated return back to work, then you may need a little bit more detail from your doctor around, now my patient is ready to attempt a return, but we need it to be gradual. It needs to be over 8 weeks or 10 weeks. We need the work setting to be limited in terms of hours or duties. That is where the doctor can provide a few more details to your employer around facilitating that return to work to make sure it's successful. But John, it's got to be endorsed by your own doctors. I don't want people to hear us saying, look, you should be capitulating to what the insurance company would have you believe, which is that you're ready to go back to work tomorrow. Your benefits should continue if your doctors are supporting that you're not able to work.
This whole chat kind of segues us nicely into something called pocketemploymentlawyer.ca. And yeah, we bring about it, we talk about it all the time on the Employment Law Show, but tomorrow we'd like to bring it up here because there's a section of there structured in Pocket Employment Lawyer about disability law too.
It is. There is. And so this is an anonymous tool. It's a plug and play type situation. What you can do is just go into the website and you can figure out to calculate what your severance might be if you're owed some severance. And you can also put in a few questions or answer a few questions around the nature of your disability and get just a few tools, some guiding points, whether you might have a case or not, and whether we might advise that you actually have a consultation with one of us. Because this is what we're here for, John. We do free consults. We talk to people about their options, no obligations, no pressure at all whatsoever, just to empower people to know, what should I do in a situation like this, Tamar? These tools allow you as a starting point to just get in, take a quick look, and make a decision around whether or not you want to take that next step and have a consultation.
Because as we just illustrated over the last 10 minutes, it's a lot of crossover between the two, so it's nice to have that tool at your disposal. Again, free and anonymous, pocketemploymentlawyer.ca is where you want to go. But email time, it is help@disabilityrights.ca. First one for the show today comes from Nathan. Writes in, says, I've been off work for the past year and I'm still on the mend after receiving rehabilitation and treatment for an injury. My insurance adjuster recently mentioned sending me back to work in 2 months' time. Since this news, I've been overwhelmed with anxiety because I don't feel I'm up to it yet. Should I go along with this plan?
Oh, Nathan, don't go along with the plan.
The old insurance adjuster.
You know, this is exactly what I've been saying the whole time we've been talking about this topic, John, is that if you don't feel ready, it could be that you're not ready. And this is really where you want your medical team to step in and provide you that guidance. I often defer a lot of people I speak with back to their own medical team to make this decision with them. Have an offline discussion with your doctor or your psychologist or your counselor or your social worker or all of those individuals, and really just get a consensus on where you're at right now. Do you need more treatment? Do you need more time? And if that time is needed, and if you still meet the test of total disability, then by all means, that is the time you should be taking, regardless of whether the insurance company is trying to force you back. That serves their needs, John. That's what they want. Because the moment you return, that obligation for them to continue to pay you can end for them. And that only serves them, not you. Because think of a scenario that you rush back and you return back to work and you're not ready from a health perspective. Not you personally, John, but if let's say Nathan did this.
Sure.
And he's not capable of sustaining his work duties, then he's not only compromising his work relationship, but he's also compromising his health in a scenario like that. And he will very likely have to go back on claim or at least pursue the disability insurer again to get further disability benefits, particularly if the doctor is recommending that, hey, the return to work was not successful. And you don't want to take that chance because it can be a much tougher road to climb with the disability insurer once they've been successful in closing your claim. Even trying to access recurrence clauses, which we know, is usually within a 6-month window. The insurer doesn't really want to go there if they don't have to go there. It can be difficult to do that. We're here to help, but I'd much prefer to see Nathan following his own medical advice, taking a more cautious approach, and if he's not ready to do it, I don't think I would follow necessarily what the adjuster is saying for him to do.
Nathan, nicely done in the email. You can always reach out with a phone call. We will tackle transitioning from short to long-term disability benefits after a short break. In the meantime, that number to reach out, 1-855-821-5900 and disabilityrights.ca online as well. We'll continue with the Disability Law Show. Stand by. People think you have to sign back a severance offer by a deadline. Employmentlawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at employmentlawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. Employmentlawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at employmentlawyer.ca. All right, thank you so much for sticking with us through a short break. Disability Law Show here. John Scholes, your host, and always with me, Tamar Agopian from Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. Anytime at all, don't fear to reach out to Tamar and a member of her team. You want to have a chat, want to learn more, something you hear on the show, you can do so. 1-855-821-5900. If you prefer the email route, that is help@disabilityrights.ca. But I want to get into this tomorrow. Our topic for this show, how to transition from short to long-term disability. I want to get through a bunch of these points and expand on them. Number one, if you are still disabled from working and your doctor or doctors agree, you should apply for LTD.
You should apply for LTD. Because it doesn't necessarily mean just because you've gone through the path of short-term, John, that you get to the long-term phase. There are forms that have to be submitted in order to initiate potentially short-term disability and long-term disability. And this is really where I want to focus on. So if you're receiving short-term disability benefits, those benefits may be coming from your employer. It could be that your employer actually has a third-party adjudication company that's looking at the disability claim, and you might be assuming that's who pays your bills. That's not what's happening. It could be that they are approving your disability claim, but in fact, those funds for your benefits for short-term are coming from your employer. So what happens when you want to or need to transition to long-term? You may actually have to submit additional forms. They'll look the same, but they are probably just directed to the disability insurer, who will approve and pay, hopefully, your long-term disability claim. And the key here is that they need, the disability insurer, 3 forms. One from you, one from your doctor, and one from your employer. And John, this is where people can sometimes be a little bit challenged because they've been off work for their short-term claim for potentially 17 weeks, 26 weeks, that's about 4 to 6 months. They may not have had regular contact with their employer during that time frame, and they may not be aware that they actually have to submit a separate application for long-term disability benefits.
Right.
You want to contact human resources, someone at your employer, to give you that guidance, because I can tell you sometimes the short-term disability providers don't even know that that needs to happen. So you can download the forms or get the forms from your employer and then submit that application for the disability insurer for long-term directly for them to make that decision whether or not you're going to be approved.
Is it always the same insurer, or is it sometimes different?
This is what I'm saying.
Yeah, another layer of hassle.
That's
right?
exactly right.
Yeah.
And so it could be that it's the same, and it could be that if it is the same insurer, you don't necessarily have to submit an additional application or form.
Okay.
But you want to know that that's true. You want to know for certain that that's the case, because I can tell you there's one insurer who likes to challenge this very routinely. They will adjudicate or administer the short-term claim and then assert that you never applied for long-term, so you're not entitled to it. How would you know? Listen to the show. I'm telling you, folks, sometimes you need to apply for long-term disability benefits as well. Best to find out. And if they've said to you, you don't need to submit additional forms, great. Get it in writing, save that email, so they can't challenge you later that you weren't entitled to it.
We are talking about transitioning from short-term to long-term disability. Point number 2 is this: continue with treatments and follow the recommendations of your doctor. You bet.
Critical.
Yeah.
Critical. Because most disability definitions to qualify for disability benefits have a continuous or ongoing component to it. So we talk a lot about this on the show, that what is total disability? Doesn't mean you're laid up in bed every day. It simply means that your health is preventing you from doing the essential, the key parts of the job that you were doing at the time that you became unwell and not able to continue working. And so your doctors do need to support when you make that application, either for short-term or long-term, that in fact these health issues are continuing and that there's treatment that's needed for those health issues. And you want those things to be somewhat continuous, because that will allow you, frankly, it's a little bit easier to transition from short-term to long-term when you're under the care of your continuous care of your doctor, taking medication, for example, or doing other treatment efforts to assist you with your disability claim.
Yeah, you kind of slipped in a little thing about totally disabled there. And again, we talk about it quite often on the show. It's a confusing thing because people, as you say, totally disabled, you can't bathe yourself, can't feed yourself, can't get out of bed, you're catatonic. That's not the case. We often use the example of, you know, if you're living and make your bread and butter being a concert pianist and you damage both hands, you are, in essence, totally disabled because you can't do your job.
It's a misnomer, John, to some extent, because even doctors don't realize what total disability really actually means. It's a contractual term, something conceived of by the disability insurers. It's frankly quite genius because it's a deterrent, right? Because you know, most people don't even enjoy that label when they're in a situation like this, and fair enough. But at the end of the day, what it actually means, what the courts have said it actually means, is that if you've got conditions, symptoms, a diagnosis, health issues that are preventing you from working, you qualify for disability benefits. It's just as simple as that, and shouldn't be the type of barrier that insurance companies have us believe. This is why we're here.
Point number 3, transitioning from short-term to long-term, is this, and we kind of got into this one. LTD approval is not automatic, but if you are denied, call you, not us, not me, call you immediately and get some help. Got to do it.
Absolutely. And it's not automatic because of what I described when we talked about point one, John, which is sometimes the payor of the benefit is not necessarily the same entity. It could be that your short-term disability benefits are paid by your employer and the long-term disability benefits are paid by the insurer. So what the insurer may do is create a gatekeeper function. Even if it's the same insurer, what they might do is administer the short-term claim to their advantage. They might approve and pay it because it's not their money. But when it comes time to actually transitioning you to long-term, folks, this is where you might get a few extra challenges because now it's the time where the insurance company is going to have to fork the bill, so to speak, and actually pay the benefit themselves. And so there can be some barriers there, but as we said before, if you've got the medical basis in place, if you're still getting that treatment, all you need to do is submit that information to the insurer and really hold their feet to the fire because it's the same actual test in most policies. John, it doesn't change.
Yeah.
So there really shouldn't be a barrier from transitioning from short-term to long-term. And so really what I think it is a financial issue. If the insurer can sort of, deny people and bat them away and just bank on the fact that you're not going to challenge them for not having made that transition, then they win. Yeah. And I want people to hear from us that there are ways to be able to do this successfully. And if you're not able to do it, this is what we're here to do, is to help support you to get those benefits that you're owed.
In addition to this lengthy TV show that we've been doing for years, we also, Tamar and I as well, host a bunch of radio shows across the country, get a ton of great calls. People listen in, they want to know things about this topic. And so we kind of cherry pick a few of those calls, play them back on here, and we all learn something from it. So we're going to get into one of those calls after a short break. That is on the way. In the meantime, the number to reach out to Tamar and her team, 1-855-821-5900 and disabilityrights.ca. Hang on, coming right back.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back. Disability Law Show continues here. Thanks for sticking around. You want to reach out after we're done for this half hour, you can do so to Tamar, member of her team. The phone number 1-855-821-5900. Help at disabilityrights.ca to send along an email. It may appear on a future show as well. And just the website, disabilityrights.ca, that is a good place to go because you will find links to our long-running radio shows pretty much across the country. Every week we host those for an hour. Tamar and myself and Savan and James, we all love doing it, and everybody has feedback as well. Listeners call in with their questions and concerns, and sometimes tomorrow we'll cherry pick a call or two. We'll play it back here and we'll talk about it. We got one for today, so we'll get to that phone call right now.
Great.
My partner's applied for LTD, and that was quite a while ago. They're taking a long time. So they just issued recently something called a without prejudice payment, indicating that, yeah, this is taking a while, and so here's some money. Are they admitting something, or is there an actual limit processing LTD because it has been a while? And should we accept it?
It's like a little LTD appetizer while you're waiting. Have this.
Have this. Take it. Absolutely take it. Look, I appreciate the call because it can be really confusing.
Yep.
How do I navigate this? How long should it take? The harsh reality, John, is that there are no set time frames about when the disability insurer is supposed to respond. It's supposed to be reasonable, however, and so I don't have a clear idea of how long, in fact, but the fact that the disability insurer here is issuing what's called a without prejudice payment tells me it's taking a heck of a long time, okay? Months is what I suspect, folks. And so, look, I think that you want to understand what is a without prejudice payment. Let's start with that. It's the insurance company saying, here's some compensation, usually it's a month or two, because of the time that it's taking for us to review your disability claim. We recognize that you're not getting any financial support, and we want to try and curb a disability lawyer like Tamar saying, hey, you took too long, you're exposing themselves to a damages claim. So they're going to issue what's called without prejudice, because they're saying we're giving it to you without in fact admitting that we are accepting your disability claim or that we've done anything wrong in the time that we've taken to adjudicate your claim. I don't see a lot of downside in accepting a payment like this, but you can't read into it that it necessarily means that your claim is going to be approved or declined. Unfortunately, you've got to wait out that process. I encourage people to put pressure on the adjuster to get them that answer. You want to get it in writing so that you know exactly what they're saying to you. Whether it's approval or denial, John, you want to get that in writing so you understand what's the basis that they're approving or denying you, and then you can make some choices around that. But here's my theory of what I think might be happening. One of the things that insurance companies like to activate is the pre-existing condition investigation, okay? This is a clause that comes up that will mean that if your disability arose within the first year of you being covered under your plan, and in that first year you may have a health issue that's putting you into that disability zone, the insurance company has a provision in their policy that says if your health issue pre-existed, if it existed before we became your disability insurer, we're going to look to see if the two are related. And if they are, we're going to rely on this exclusion to deny your claim. And when insurers do this kind of pre-existing exclusion investigation, John, sometimes it could take a long time because they're looking to gather a lot of historical medical information to allow them to make that assessment. So it could be that that's what's happening here. It's not right, but that is part of my theory of what may be happening here. And in the vein of that, if they think the outside of that investigation is going to lead to them to say, we can't rely on this exclusion, and they haven't paid you for months at a time, it's not a good look for the insurance company, which is why they issue these kinds of payments.
Does that pre-existing condition thing, is that stick in your craw all the time? I mean, is it a bit of a reach? Yeah.
It is a bit of a reach, and it's one that I think is getting routinely used almost as a sword as opposed to a shield. It's meant to really protect the disability insurer, frankly, from individuals who might be insurance shopping, who may have terminal illnesses and are just trying to get on a plan. But that's not really how it's being used in practice. Adjusters are seeing the fact that you're within that 1-year window, and they seem to be more routinely activating this type of clause because inevitably they're looking for ways to decline the claim. And this is an easy one, because what the courts have said is that it can be sort of an all or nothing type situation. Either the insurer can rely on the clause and say we're denying your claim on this basis, a technical one, but one that's solid, or the insurance company is meant to pay and therefore should be adjudicating the claim on its merits and paying the disability benefit on that basis. But if the insurance company can find a quick way to decline right out of the gates, John, then they're going to take that opportunity.
It seems like a decent tactic for them to use, but by the same token, you're obviously not strange of dealing with this sort of situation, so people should still be reaching out if they get that said to them, right?
Absolutely, and especially if you're getting the runaround from your adjuster. It shouldn't take that long to make a decision, and it shouldn't take that long to issue without prejudice payment either. So typically, once you apply, you should be getting a response from the disability insurer within a week or a couple of weeks, at least acknowledging that we've received your application, we're reviewing it, this is what phase it's in, and we're going to get back to you in the next period of time. I absolutely understand that sometimes they cannot necessarily meet those kinds of deadlines, but the other side of that coin is you've got individuals who don't have any money, have no income coming in, and they are relying on this disability benefit to support them. So if it's not reasonable, then you really do want to make sure that you're documenting what's happening with your exchanges with the insurance company and putting that pressure on them to make sure that they're giving you a fair response and a fair shake.
That is pretty much it for another show. And by the way, once you start a claim with Tamar and her team, guess what stops? All the phone calls, all the quietness from the insurance company. That's a nice fringe benefit. But you can investigate that by reaching out 1-855-821-5900 anytime. And disabilityrights.ca is the website. We'll catch you next time on the Disability Law Show.